The Supreme Court chamber was a study in contrasts that morning. The rich mahogany woodwork glowing under the soft light, the black robes of the justices stark against the marble, and the palpable tension that hung in the air like a storm about to break. Court observers, legal scholars, and journalists filled the gallery, their whispers barely audible as they awaited the day's proceedings. The case on the docket, Fulton versus City of Philadelphia, a critical religious freedom dispute, had already drawn intense scrutiny, but no one expected the seismic confrontation that would unfold. Chief Justice John Roberts, the measured centrist who had helmed the court since 2005, sat at the center, his Harvard pedigree and establishment aura as palpable as ever. To his right, Associate Justice Amy Coney Barrett, the court's newest member, appointed by President Trump in 2020 after Ruth Bader Ginsburg's passing, adjusted her notes with a calm that belied the storm brewing. Barrett, a Notre Dame law professor turned federal appellate judge, had faced relentless criticism during her confirmation, her devout Catholicism and mother-of-seven status weaponized by detractors. Yet she'd maintained a steady, methodical presence on the bench until today. The tension had been building all morning during oral arguments. Barrett's penetrating questions about First Amendment religious protections hinted at a new framework, one rooted deeply in constitutional text and original meaning. She referenced an obscure 1887 precedent, challenging the established approach Roberts had long championed. "Justice Barrett," Roberts interrupted, his voice carrying an unusual edge. "The court has moved well beyond that antiquated reasoning." Barrett nodded respectfully but continued her line of questioning, her depth of constitutional understanding impressing even the veteran attorneys arguing the case. Journalists in the press gallery exchanged glances. This wasn't the usual, collegial exchange. The first crack appeared when Justice Samuel Alito built on Barrett's point, suggesting her analysis offered a more textually faithful reading. Roberts's face tightened, his discomfort evident as other justices seemed to rally around Barrett's perspective. In the justices' private post-argument conference, the tension boiled over. As Barrett explained her position, Roberts cut her off, his tone sharp. "We have established procedures for interpreting these clauses," he said dismissively. Witnesses later reported that he spoke over her, an extraordinary breach of the court's collegiality. Justice Clarence Thomas raised his eyebrows but stayed silent, the air thick with unease. The confrontation spilled into the public session that afternoon during discussion of a separate case. Roberts, appearing to seize the moment, looked directly at Barrett and delivered a stunning remark. Perhaps Justice Barrett, with her limited experience, might want to recuse herself from this constitutional interpretation, he said, his voice steady but pointed. After all, these complex frameworks developed while she was still teaching law school basics. A collective gasp swept the courtroom. Never in recent memory had a Chief Justice so openly challenged a colleague's competence in open court. Court artists sketched frantically as Justice Sonia Sotomayor, though ideologically opposed to Barrett, looked visibly uncomfortable. Justice Brett Kavanaugh glanced at Barrett with concern, while Justice Elena Kagan studied her notes, avoiding the spectacle. The room fell silent, all eyes on Barrett. She sat perfectly still, her expression unreadable, as Roberts suggested her. Newcomer perspective might benefit from more observation. The tension was palpable. Court observers held their breath, wondering how the newest justice would respond to this unprecedented attack from the nation's top jurist. Barrett straightened the papers before her, took a measured breath, and looked directly at Roberts. Her voice, calm and perfectly modulated, carried through the chamber. "Thank you, Chief Justice Roberts, for your concern about my experience," she began, her tone respectful but firm. "I believe my years teaching constitutional law have indeed prepared me for this role, just as your time in private practice prepared you for yours." The reference was precise, a subtle reminder that Roberts had never served as a judge before his appointment as Chief Justice, while Barrett had years of judicial experience. She continued, "However, I think we might all benefit from examining the actual text of the Constitution on this matter, rather than relying solely on frameworks that have evolved over time." Reaching for a small, worn copy of the Constitution she always carried, Barrett quoted precisely from 5 sections, connecting them with clarity that demonstrated a remarkable command of constitutional structure. And perhaps most relevant to our discussion today, she added, is the original understanding of the First Amendment's religious protections, which James Madison outlined in his 1789 address to Congress. She recited the complex passage word for word, a feat later confirmed as flawless by legal scholars. In light of these foundational texts, Barrett concluded, I must respectfully disagree with the characterization that faithfulness to original meaning represents inexperience rather than judicial discipline. The courtroom remained silent. Justice Thomas nodded in approval, a rare gesture from the typically stoic justice. Justice Kagan looked up, a new respect in her eyes, despite their ideological divide. But Barrett wasn't finished. In her most devastating point, she referenced a law review article Roberts had written early in his career, advocating for the text-focused approach she now championed. As a young attorney, you eloquently wrote that the court's highest duty is fidelity to the text above all institutional considerations, she noted, quoting his own words from 35 years earlier. I have always admired that perspective, and I'm simply attempting to honor it in my service to this court and the Constitution. Justice Alito suppressed a smile, while Roberts, for perhaps the first time in his tenure, appeared at a loss for words. The man known for verbal agility sat frozen, his dismissiveness replaced by stunned silence. A veteran Supreme Court reporter later called it the most elegant evisceration of a Chief Justice in the modern era. Without raising her voice, Barrett had dismantled Roberts's attack, establishing her intellectual dominance on the constitutional questions at hand. Roberts finally spoke, his voice less confident. Thank you, Justice Barrett, for that comprehensive response. The court will take all perspectives under advisement. But everyone understood what had happened. In less than 3 minutes, Barrett had transformed from the court's newest member to its most formidable constitutional mind. The repercussions were immediate. Within hours, legal blogs dissected every word of the exchange. The hashtag #YarBarrettBrilliance trended nationwide, with law students and scholars analyzing her response. Clips of the moment garnered over 5 million views on social platforms, constitutional experts weighing in. Inside the court, the atmosphere shifted overnight. Justice Thomas approached Barrett, quietly saying, "That was long overdue," smiling. Broadly as they walked to their chambers, Justice Alito told a clerk Barrett's response would be taught in law schools for generations. Even Justice Sotomayor told her clerks the exchange underscored the importance of deep constitutional knowledge, regardless of philosophy. The next morning, Roberts arrived early, carrying constitutional history texts. A court employee revealed he'd requested James Madison's complete writings from the Library of Congress, revisiting the texts Barrett cited. At the next public session, Roberts consulted Barrett before arguments, leaning toward her with newfound deference. He didn't interrupt her once, a marked change. In the justices' closed-door conference, Roberts asked Barrett to explain a jurisdictional question before offering his own opinion, an unprecedented act of deference to the court's most junior member. Justice Kagan was reportedly stunned by this reversal of protocol. Barrett was assigned to write majority opinions in 2 major cases the following week, a rare responsibility for a junior justice. Her constitutional framework began appearing in draft opinions, including a partial concurrence from Justice Stephen Breyer, adopting her textual analysis. The media split along ideological lines, but with exceptions. Conservative outlets celebrated. Fox News declared, "Barrett proves her critics wrong." National Review wrote, "Constitutional brilliance silences doubters." Liberal scholars like Harvard's Alan Dershowitz on CNN acknowledged, "Barrett's command of constitutional text and history is extraordinary." A New York Times progressive scholar wrote, "Her textual approach, while leading to outcomes I disagree with, is applied with remarkable consistency." A week later, Justice Kagan cited Barrett's framework during oral arguments, suggesting, It offered clarity, a sign Barrett's influence transcended ideology. President Biden, watching the exchange, reportedly told his judicial selection team to prioritize constitutional textual expertise in nominees, saying, "That's what Americans deserve on their highest court." Senate Judiciary Committee hearings began emphasizing constitutional text. Senator Lindsey Graham, holding up a pocket constitution and asking nominees to cite judicial power language, echoing Barrett's demonstration. Law schools saw a surge in applications to constitutional law programs. The Barrett-Scalia Textualist Society at Georgetown Law tripled its membership. Columbia Law School's dean noted, "We're seeing unprecedented interest in originalist methods, even among students who don't share conservative outcomes."